Hi, Gov students. I want to talk about civil rights, which are in contrast to civil liberties. So while civil liberties are things that the government cannot do to you, civil rights is the idea of government treating everyone equally under the law, that there can be no distinctions between races, genders, religions. You can't treat people differently, all right? And this comes from our wonderful 14th Amendment, again, which has not only that due process clause that states can't take away your liberties, but also an equal protection clause. States cannot treat people differently. Obviously, up through the 1960s, we had state-sanctioned racial segregation, which was in violation to this equal protection clause of the 14th Amendment. And so the Supreme Court as a vehicle for civil rights doesn't really take off until the 50s and 60s and later. So equal protection applies to mostly three main groups. I'm going to explain this all in a second. So you've got race, gender, and religion are your three what are known as they're protected categories. So what that means is that if you want to discriminate based upon race, gender, or religion, you have to have a damn good reason to do so. And the Supreme Court is going to make you prove that you have a damn good reason. So, for example, if a Catholic school wants to give preferential hiring to Catholics over non-Catholics, right? The reason being that at many Catholic schools you have to sign a tenet of faith saying you will do all these things and not disobey the Catholic Church, right? They want to give preference to Catholics because Catholics have to abide by that, right? Or if you want to discriminate based upon gender, right? If you want to have an all-girls school, you have to have a damn good reason to do so. There are lots of Supreme Court cases that deal with these issues, right? So with race, we've got the Brown versus the Board of Education, right? Which said, states, southern states said, hey, we want to segregate white and black, and here's our reason. And the Supreme Court said that is not a good reason. That's a bad reason. Separate but equal is no good. Overturning separate but equal, we must integrate schools and all public facilities. And you have affirmative action cases, which apply to both race and gender. This is, some people call it, quote unquote, reverse discrimination, but basically offering preferential admission criteria or admission standards to people who may be from races, ethnicities, or genders who have been historically disenfranchised or disadvantaged in the United States. And so the argument there is that, we have a damn good reason. Diversity is good, right? Diversity helps supply education, educational benefits to everyone at the school. And so we have a vested interest in advancing the causes of diversity by admitting more minorities, people who are black or Latino or women. And the Supreme Court has generally agreed with schools in those cases, right? That reason is sufficient, according to the Supreme Court. Although with affirmative action cases, schools cannot have quotas. So there's a Supreme Court case, Backey versus the Board of Regents of California. Supreme Court said, yes, diversity is a sufficient interest for a school, but you can't set aside a certain number of seats for specific ethnic groups or gender groups. So while you can take into account diversity, you can't set aside slots. Okay, so these are your three protected groups. You should know Brown versus Board of Education, important case. You should know the case I just said right there, Backey versus the Board of Regents of California. And then there's LGBTQ. So the reason why I've set this off to the side and put question marks is because it's not really a protected category yet. So there's not a level of scrutiny that you have to meet at the Supreme Court or court levels to discriminate against LGBTQ people, right? So there's that case of the baker in Colorado doesn't want to bake a cake or whatever, or gay marriage, right? We didn't want to, but recently this has shifted. The Supreme Court and other courts are seeing gay rights as important and starting to provide more protections for LGBTQ people. Obergefell v. Hodges is the case that legalized gay marriage. throughout the United States, overturned gay marriage bans. And so the question is, are LGBTQ people going to be included in this group, in these protected categories, protected classifications? If they are, then it becomes a whole lot harder to discriminate against LGBTQ people, right? So right now you have to have damn good reasons to discriminate against all these groups. Really damn good reasons, right? Like, we can't have men-only military academies anymore because the argument was, well, women, they're not sufficiently strong enough to serve in the military or whatever, and that wasn't deemed not sufficiently good reason because it's just not true. Same thing with prison guards. There used to be essentially you had to be a man to be a prison guard because you had to have a certain amount of strength. They said that's just not, women can be just as strong as men, prison guards. So those sorts of things, right? But it's really easy to discriminate against LGBTQ people now. And so the question becomes, at what point, if it ever becomes, at one point or when will it become a protected category? Obergefell v. Hodges is sort of the first step. Government did not have a good reason to discriminate against gay people in terms of marriage. This baking of the cake issue, can private companies discriminate against gay people based upon their religion, right? Religious preferences. That'll be a big case to see whether or not how much protections they want to give to LGBTQ people, right? Versus how much weight they want to give to freedom of religion, the free exercise of religion. From the last video, civil liberties, you are free to exercise your religion. If your religion calls you to violate equal protection, is that okay? Big question. So this is the Equal Protection Clause of the 14th Amendment. This is where we get civil rights in all our civil rights cases. And this discussion wraps up our discussion of civil rights and civil liberties.